Thank you so much, Steve. So we've got a couple of questions from our audience today, but before we get into those, I'll give our sixth and final secret word of the day, which is claim. That's C-L-A-I-M. So secret word number 6 is claim. And our first question from the audience, Roger, it's directed towards yourself, but it's open to all of our panelists should they wish to give their input as well. But Roger, how do I select a mediator? Perhaps there's some tips that you could share there. And the other part of this question, should one rely on published experience and credentials, or is there anything else that should be considered? So Roger, that was a question for yourself. You may need to unmute your line, but just to reiterate the question again.
I'm sorry. That's an excellent question. And actually, I had intended to get to it, but for the issue time. Selection of the mediator, herself or himself, it can be determinative of the entire fate of your case. And several things stand out. Number one, and you hit it on the head, credentials, paper credentials, they're great, but they do not carry the day. And they can be misleading because two things are required of a good mediator. Number one, they must be a hard worker. They have to do the work before you even sit down. And in many cases, a mediation statement will be 5 to 10 pages. But you're allowed, whether under court rules or other rules, to attach addenda, even documents, could be 2 inches thick in a binder. And it's not uncommon. But if you have a mediator who doesn't read it and go over things painstakingly and doesn't know in advance as much about the case as you do, they're not going to be able to perform their main function. And you know what that is? It's to cast doubt in the minds of the plaintiff and in the minds of the defendant. And a good mediator's got 2 hooks to do just that. One is on the issue of liability, and one is on the issue of damages, and privately work both parties over on the questions that exist as to both. So in order to do that, they've got to do their homework. They've got to know their case, and they've got to know your weakness. So when you ask about published criteria, that doesn't tell you anything about their work ethic, and that's really key. Secondly, they've got to have a good demeanor where they don't tip their hand and they work evenly with both sides and are willing to be what I call a mediator giving a reality check, not just shuttle back and forth and trade numbers. So I wouldn't rely on published criteria. I take a look, but I would talk to people who are involved and maybe have been in similar cases before, or other attorneys and all. That's really the best thing. And don't be afraid of selecting, believe it or not, as someone who is suggested by the other side. And I know that's going to be counterintuitive. And if you're an attorney and running your client, or you're a client reporting to CEO, well, yeah, we got this mediator, but the other side proposed them. You know, they may think that you haven't done your job, but kind of au contraire, because if the other side selects that mediator, her or him, then they're going to trust them. They're not going to, or her, they're going to be relying on that person. And if they rely on that person, then that person has leverage to move them in your direction towards a settlement. So, yeah, look at the paper criteria, but talk to people, vet them well outside the paperwork. That's just so important. So I hope that answers the question.
Thank you so much, Roger. A quick follow-up question. So you've selected your mediator, but the mediation hasn't been successful. What's the next step? Is it always a lawsuit, or is there anything else that could be considered?
Well, you never give up. You know, it was referenced earlier by Tracy, and it was well put, that maybe your mediation hasn't worked, but a good mediator, it doesn't give up. And that's kind of their mantra. So after the mediation, they're going to be contacting you. If you got the right mediator, they're going to call up and they're going to go, hey, Roger, what's, I think I can get the other side to move, but you got to do something serious here. Let's put this thing to rest. And I've gotten a little bit of extra traction since we concluded this thing. Then they'll call up the other side and say, hey, I don't know why this thing didn't settle, but I think I got Roger ready to move a little bit more, even above and beyond what we accomplished. So at the session. So no, you never give up. And as far as that session goes, don't constrain yourself to one day or closing up at 5 o'clock. Before you schedule a mediation, you can actually schedule a couple days, all right, 2 days in sequence, or if it doesn't work, we'll do 10 days later. But leave yourself flexibility so it's not like, Cinderella and everything changes at midnight or 5 o'clock. You keep the process going. Because, ultimately the case probably is going to settle. And why do it only after you spend a lot more money and a lot of executive time when you can say, well, it didn't work yet, but let's continue trying. I'll give you one example. I did a federal mediation where the parties were $13 million apart. We didn't get very far, but made progress. And at the end of the day, even though it was discontinued, the president of a major Midwest construction company and a CFO of a significant utility were seen sitting down having coffee together afterwards. What that means is I wouldn't treat a mediation as unsuccessful. I'd just treat it as a pathway with the door still open. So keep at it. That's my thought.
Thank you so much, Roger. Tracy, we've got a couple of questions here for yourself that we'll try and squeeze in before we close up things today. But the first one that we've got for you was you mentioned a lot about the complex litigation problems that can arise when drafting the construction's contracts. Is there any way to avoid these types of complex litigation issues that may happen to present themselves?
There's possibilities of doing so in the AIA contracts. There are ways to make sure that each party, is not, from a defendant's perspective, there are ways to make sure that a party is not liable for another party's damages. So, there are some things with respect to perhaps the joint and several liability issue in some states that do allow joint and several liability in contracts. You could put into your contract that, that you under no circumstances will be liable for another party's damages. And so that could help. It's hard to say because, again, as these problems are kind of different in different states. But I do recommend, a lot of contract drafters, many construction contract drafters are also litigators. But to the extent you're having a lawyer draft your construction contracts who are not litigators, I would definitely bring a construction litigator in when you are drafting contracts, because I think that litigators can make a huge difference when you're doing your actual construction contracts. A lot of even the things like with what Stephen referenced about the force majeure clause, or what Roger mentioned about the mediation and the arbitration clauses. Rarely do deal people or transactional lawyers bring in litigators to review contracts when they're drafting them, and I think that is a huge mistake. So bring in litigators when doing contracts.
Thank you so much, Tracy. And this last question that we will close out with, it's for yourself, but Roger, if you want to chime in, you're more than welcome to do so as well. But Tracy, can you give perhaps an example of how you would allocate damages to a settling defendant in a case where the plaintiff has suffered an indivisible injury?
So this is one part I didn't really get to touch on, which is about the allocation. There are some states that allow you to allocate to various defendants or to the settling defendant in the settlement agreement. Now that can be difficult because those are drafted by attorneys, but to the extent that if there is something that you can point out that is not part of the indivisible injury. That, for example, like with respect to the shoddy construction I was talking about with the general contractor, you basically had missing grade beams. Well, we paid for a certain number of grade beams, and we didn't get all the grade beams that we paid for. So, you know, that could be a separate damage that you could then allocate that separate damage. Attorney's fees. What about all the attorney's fees that we spent on that one particular defendant? You might be able to allocate that and put that into the settlement agreement. It's pretty difficult. So, but I think, you know, so with some creative thinking, there could be ways to do it with respect to trying to separate out separate damages.